Greetings, class. So right now I'm going to talk more about what the employer and the employee's duties and rights are in collective bargaining in the labor law section. So I'll go through some of the limitations on conduct and also the rights on conduct for the employer and for the employee. So as we talked about in the other session, I talked about how the Congress had decided that first it needed to affirmatively encourage the employer and the employee to bargain and to engage in collective bargaining and negotiating the terms and working conditions. And then that then passed on to the courts to figure out what to do when there was a conflict that wasn't resolved by bargaining between the parties. So the courts had to balance two sometimes conflicting rights, which is the employee's right to use economic pressure, and I'm going to talk about what kind of economic pressure the employee can exert, but then also the employer's right to property. The employee's right to property includes the right to control who goes on the employer's property, what is done on the employer's property, and then how the employer's property could be harmed by the conduct of the employee. So the court has to balance those two rights. On this next slide, I have a list of those practices that are defined as union unfair labor practices. If you remember, what the Taft-Hartley Act did was to define what employees have done or can do that would be unfair labor practices. And those include feather bedding, which is kind of an interesting term, which just means that the union requires like extra workers. Charging excessive fees, those would be union dues, for example. Refusing to bargain is a big one. That is one that employers and unions can be held liable for, and since the whole point of the labor law is to encourage them to bargain, if the union doesn't bargain or doesn't bargain in good faith, then that's an unfair labor practice. Coercion as to employees as well as to the employer. Coercion, trying to force someone to become a member of a union, trying to force an employer to, for example, accept feather bedding. Those are all things that are union unfair labor practices. And then causing the employer to discriminate. The idea of that one is that if the employer, if the union tries to get the employer to treat an employee differently because of union membership or not union membership, then that's an unfair labor practice by the union. So what do unions do to try to apply economic pressure? Well, they have several things that they do, and I've outlined three key things. The other is work stoppage or work slowdown, which I don't specifically talk about other than in the context of strikes. So on this slide I have the three major ways that unions use to apply economic pressure. And a strike is probably the most dramatic and the most dramatic of those three. So the picture I have on this slide is of a dog that's gone on strike from digging and has a sign that says on strike. A strike is then a work stoppage where all the employees decide that they will no longer do the work for the employer in hopes that economic pressure will force the employer to either negotiate or negotiate in a way that's more favorable to the workers and more favorable to the union. The key of the strike is that it's the workers themselves that have stopped working. A boycott can be by the workers trying to encourage people not to patronize an employer, or it could be sometimes by outsiders who, like customers and others, who encourage a boycott. Pickets are the method that the workers use to notify the public that the workers believe that the employer is not negotiating properly, or that the employees are not getting fair wages. And so the pickets are the people that walk around in the sign. So the strike with the signs. So the strikes are the people who are no longer working, and the pickets are those usually workers who are now walking around the workplace to try to encourage people to not patronize that employer. And the pickets are okay as long as the picketers don't actually get on the employer's workplace without permission. So you'll often see picketers who are walking on the sidewalk outside of an employer's place of business. There are primary and secondary picketing. Primary is picketing the immediate employer. Secondary picketing is picketing a customer or supplier of the employer. Generally, the law doesn't favor so much the secondary picketing, but primary picketing is legal. One of the key issues that comes up with picketing is the right to freedom of speech by the employees. And the courts have to decide what the balance is. States can't infringe on First Amendment rights to freedom of speech. At the same time, the states can protect community peace and privacy. So an employer who is going to court to ask the state, the government, the courts, to respond to a strike or to picketing or to boycotting, the employer has to convince the court that an injunction, for example, is necessary to protect the community peace and community privacy, and at the same time convince the courts that this doesn't unnecessarily infringe upon the First Amendment right to freedom of speech. And there have been a lot of cases that have talked about this, and I'm not going to discuss that here, but I just want you to be aware that on the one hand you have the employees who have the right to apply economic pressure, and one of the ways they do that is through picketing. But on the other hand, the employer has the right to stop the workers from, say, destroying the property, such as you see in the picture on the right. One of the quotes that I like to use in talking about what the courts do when they're analyzing this economic pressure is a quote from an old case, a 1946 case, and what the court said was, when a picket line becomes a picket fence, it's time for government to act. And I guess I just like that saying because it illustrates through analogy what the courts are trying to do to balance whether it's appropriate for the court to step in and grant an injunction. So I would just want you to think about any pickets that you've seen. The NLRA's purpose is to permit the exercise of one right with as little interference with the other as possible. So what are those rights? On the one hand, you have the employer's property right and the employer's duty not to interfere with the employee's right to organize. On the other side of this balance is you have the employee's right to organize. And as I mentioned, the NLRA is trying to figure out what the appropriate balance is so that they're equal rather than one being more powerful than the other. In this slide, I just give you a list of the employer unfair labor practices. They include interference with the union or with interference with organizing, not just a union, domination of the union, discriminating for union activity relating to working conditions, discrimination for filing charges, and then refusing to bargain. Of the ones that happen, refusal to bargain is the one that gets the most publicity, but employers have to be careful not to interfere with the unions or the employees' efforts to organize, while at the same time the employer has the right to present evidence or present an argument why the employees shouldn't organize and why the employer is fine or employment working conditions are fine as they are. And so that can be a key issue for an employer to try to figure out how to present the employer's position without it being considered interference. The NLRB, although it's been very pro-employee since its existence, it was created under the Wagner Act, under the National Labor Relations Act, so it sort of was employee oriented. But I'd say over the past 20 to 25 years, as our society has changed, the NLRB has become increasingly conservative in favor of the employer. So the employer has less to be concerned about in terms of interference with workers' collective bargaining efforts. So, it's an unfair labor practice to interfere with, restrain, or coerce employees who are engaged in union activity, or to discriminate against employees for such activity or for supporting a union. There used to be a saying, and it still may be true, that the shop steward never gets fired. And that's because it's so hard for the employer to feel convinced enough or demonstrate convincingly enough that the union steward was fired for failure to perform the job, as opposed to being fired for participating in union activity. So managers have to keep a well-documented paper trail. Employers have to keep a well-documented paper trail, especially on union employees, in case they decide to let a worker go. And that's what the picture is of a worker being let go. In terms of interference, restraint, or coercion, I just list several ways that it can exist. I don't have time to explore those in detail. That would be for a labor law course. So the interference, restraint, and coercion of employees' rights section says that an employer cannot, because it's an unfair labor practice, an employer cannot threaten employees either directly or manipulate benefits or job conditions. On this one about manipulating benefits or job conditions, that has happened more recently, and the NLRB has, I don't know the right way to describe it, because they don't accept it, but the NLRB has been maybe slightly more accepting than it had been in the past. Asking the employee about whether the employee is interested in a union is considered interference, restraint, or coercion. It's presumed to be coercive. So if an employer does want to find out about union support, the employer must follow strict guidelines. So before doing a poll, that employer should consult with an attorney or with the NLRB to make sure that the employer is following the guidelines. An employer can prohibit union activity, but it has to be, employer has to be fair in, if they're going to prohibit union activity, they have to prevent all other types of activities, whether that's selling Girl Scout cookies to, any other activity. If they do it fairly, then there's not an issue. If they pick only union activity to prohibit, then the employer will be in trouble. And then, of course, they can't prohibit union activity on non-company time. Employers can't engage in surveillance or espionage, planting someone with the workers who are talking about organizing and then getting feedback, filing a libel suit to just retaliate for a strike. All those things are prohibited as unfair labor practices. And then the NLRB certifies what's an appropriate bargaining unit for a union. So the NLRB has to evaluate which employees fit within the appropriate bargaining unit and examine community of interest. That was an issue that was raised when the football players union was first created. Whether, or was that baseball? I'm sorry. It might have been baseball. And the idea was that what if the NLRB created the bargaining unit based on teams versus nationwide? And the court said, no, you can't do that, because basically that dilutes the power of the union. Once the union is certified, management has a duty to bargain in good faith, and the union has a duty of fair representation. Refusal to bargain is an unfair labor practice, whether it's the employer or the employee. The employer must bargain over mandatory subjects of collective bargaining. Those are the terms and conditions of employment. And then can choose to bargain over permissive subjects. So what are mandatory subjects? Wages, piece rates, shift differentials, incentives, bonuses if they're compensation, seniority, layoff or recall, no strike, no lockout clauses, grievance procedures, work rules. Those are mandatory subjects of collective bargaining. You must know as an employer which of those subjects are mandatory subjects. Benefits, previously retired, interest arbitration, expanding the bargaining unit, baseball, the player draft, reserve clauses, merger non-compete. Remember that baseball is exempt from antitrust laws, and so that's why baseball is treated a little differently in collective bargaining and what must be mandatory versus what's permissive. Then there are some areas that are kind of wishy-washy or gray areas. Subcontracting rules, business closing and relocation, and then bargaining unit work. It just depends on whether the employer has a good faith business reason for not negotiating in those areas. And if the employer does have a good faith business reason, then there's no duty to bargain. Okay, what I have here is I had looked at an NFL players president's recommendation that the Ultimate Fighting Championship fighters also consider unionizing. So it's a UFC, mixed martial arts. There's been discussion of a union. There hasn't been one yet, but it could be a possibility. The idea is that there could be more health benefits, perhaps more livable wages, and balance the economic power, because one fighter versus a multi-million-dollar owner, obviously the economic power is with the multi-million-dollar owner. I have two of my sons are very much into ultimate fighting, and I've in the past had my oldest son come and talk about whether the UFC fighters should unionize or not. Because of the way they're paid, they do 3 or 4 fights a year. If you're not very good, you get maybe $20,000. If you're really good, you can get much bigger purses. And then the other thing that I recommend is that you look at the NFL contract. And that we may have time to do in class. If you don't, I'd just like you to look at that 300-page contract. The link I've given here is the searchable one, so that you could search for a specific topic, although it does have a table of contents. And for those interested in marketing, you may want to look at what it says about endorsement contracts. So that's it. Thanks for listening.